On July 2, 2026, the ATF issued Ruling 2026-1, formally determining that the projectiles and projectile cores used to assemble SS109 and M855 cartridges are exempt from the definition of armor-piercing ammunition under 18 U.S.C. Section 921A-17B. Green tip is protected under federal law, not just the loaded cartridge, the steel core projectile itself. To understand why that distinction matters, and why this ruling is more significant than the headline suggests, you need the 40-year story behind it. In 2015, the Obama ATF tried to strip the M855 exemption entirely. It would have cut off the supply of the most popular AR-15 ammunition in the country at the source. No new manufacturing, no new imports, no new sales. It failed. Stopped by 80,000 public comments, a letter signed by 238 members of the House of Representatives, and a political firestorm that forced a withdrawal 3 weeks after the proposal was published. 11 years later, the Trump ATF went in the exact opposite direction. It did not just preserve the exemption, it extended it, formally, permanently, through a binding ruling that a future administration cannot simply announce away. Understanding why requires starting with the statute. The Law Enforcement Officers Protection Act of 1986, LEOPA, added the armor-piercing ammunition definition to 18 U.S.C. Section 921A-17. Congress's stated purpose: protect law enforcement officers from handgun ammunition capable of penetrating soft body armor. The definition has two prongs. Prong 1 covers a projectile or projectile core which may be used in a handgun and which is constructed entirely from one or a combination of tungsten alloys, steel, iron, brass, bronze, beryllium copper, or depleted uranium. Prong 2 covers a full jacketed projectile larger than .22 caliber, designed and intended for use in a handgun, and whose jacket has a weight of more than 25% of the total weight of the projectile. Stop there, because the legal definition is nothing like what the name implies. The armor-piercing definition under federal law has nothing to do with whether a round can actually penetrate body armor. It is about the materials the projectile is made from and whether it can be used in a handgun. Common hunting rounds in .30-06 or .308 will defeat soft body armor in the field, and they are not armor-piercing under federal law because they are made from lead, not the listed metals. Legal definition and common sense are not the same thing in this statute. Here's the other thing most gun owners do not know about how this law actually works. The federal restriction on armor-piercing ammunition does not prohibit possession. It prohibits manufacturing, importing, and selling. The supply chain is regulated. The end user is not. A private citizen can legally possess armor-piercing ammunition under federal law. What the statute cuts off is the commercial pipeline that gets it to them. The statute also gives the Attorney General authority to exempt from the definition any projectile the AG finds is primarily intended to be used for sporting purposes. That exemption authority is in Section 921A-17C. It is the legal mechanism that has protected M855 since 1986. When LEOPA was enacted, the ATF immediately used that sporting purposes authority to exempt 5.56mm SS109 and M855 green tip ammunition containing a steel core. The exemption was straightforward at the time. In 1986, there were no commercially available handguns chambered in 5.56mm. The only firearms that used M855 were rifles. A round that could only be used in a rifle posed no threat to a law enforcement officer wearing soft body armor from a handgun attack. Sporting purposes exemption granted, problem solved. But the exemption covered the loaded cartridge, the SS109 and M855 cartridges, as finished products. The steel core projectile itself, technically speaking, remained classified as armor-piercing under the statute's materials test. For manufacturers loading factory ammunition, the exemption covered the end product they sold. For reloaders and component manufacturers dealing in loose projectiles and cores separately from the loaded cartridge, The legal status of those components was never formally resolved by the 1986 exemption. That gap sat quietly in the law for nearly 30 years. Then, the AR pistol arrived in the commercial market. Starting around 2011, AR platform pistols chambered in 5.56 millimeters became widely and commercially available. Under the statute's definition, armor-piercing ammunition is defined partly by whether it may be used in a handgun. Once 5.56 millimeter handguns existed in the commercial market, M855's loaded cartridge technically qualified as armor-piercing under the materials test, because it could now be used in a handgun. The 1986 exemption had been granted on the basis that no such handgun existed. That basis had changed. The Obama ATF recognized the argument and published a framework document in February 2015, proposing to withdraw the M855 exemption on exactly those grounds. The proposal was specific about consequences. Manufacturers would be unable to produce such ammunition, importers would be unable to import it, and manufacturers and importers would be prohibited from selling or distributing it. Possession would remain legal, but supply would be cut off at the source. The existing stockpile would be all that remained. The response was immediate and overwhelming. Roughly 80,000 public comments flooded the ATF, the vast majority opposing the change. 238 members of the House signed a letter to ATF Director Todd Jones. Senators wrote directly, "Second Amendment rights require not only access to firearms, but to bullets. If law-abiding gun owners cannot obtain rifle ammunition or face substantial difficulty in finding ammunition available at reasonable prices because government entities are banning such ammunition, then the Second Amendment is at risk." The ATF withdrew the proposal on March 10, 2015, 3 weeks after it was published. The exemption was preserved. But here is what that withdrawal actually left behind. The exemption survived by political pressure, not by a formal legal ruling, not by a binding agency determination under Section 921A-17C. The underlying legal vulnerability, the AR pistol problem, the question of whether 5.56 millimeter ammunition could still qualify for the sporting purposes exemption once handguns chambering it became commercially available, was never formally resolved. It remained an open legal question. A future administration could revisit it. A future ATF director could publish a new framework. The 2015 victory was real. It was also fragile. ATF Ruling 2026-1, effective July 2, 2026, is the formal resolution of everything the 2015 withdrawal left open. The ruling determines that the projectiles and projectile cores used to assemble SS109 and M855 cartridges are exempt from the armor-piercing definition under 18 U.S.C. Section 921A-17B. The ATF concluded that these projectiles are likewise primarily intended for sporting purposes and therefore must be included within the existing exemption. The 1986 exemption covered the loaded cartridge. The 2026 ruling extends that exemption to the loose projectile and projectile core components themselves. The practical scope of that extension matters most for reloaders and component manufacturers. If you purchase steel core 5.56 millimeter projectiles as loose components and assemble your own cartridges, the legal status of those components was previously unresolved by formal ruling. As of July 2, 2026, that question has a formal answer. Exempt. The ATF's own ruling, issued under the AG's Section 921A-17C authority, classifies the SS109 and M855 projectile cores as primarily intended for sporting purposes, and therefore outside the armor-piercing definition. One line from the ATF's own announcement is worth stating precisely. This clarification applies only to these specific projectiles and cores. It does not change the broader regulation of armor-piercing ammunition. That scope limitation matters. Ruling 2026-1 resolves the SS109 and M855 question. It does not resolve the dozens of other pending exemption requests the ATF has been holding since the 2011 wave of applications from manufacturers seeking sporting purposes exemptions for other steel core projectiles. Those requests, approximately 30 of them, covering a range of calibers and configurations, remain in the ATF's regulatory queue without formal resolution. Whether the ATF addresses those next or uses the same analytical framework it applied in Ruling 2026-1 to clear that backlog is the open question that follows this ruling. Now let me give you the compliance picture precisely, because the way this ruling applies depends on what you actually do with this ammunition. If you buy factory-loaded M855 or SS109 ammunition, your status under federal law has not changed from what it was before July 2, 2026. The loaded cartridge has been exempt since 1986. You have been buying legally compliant ammunition all along. Ruling 2026-1 adds formal protection for the components, but does not change the legal status of the finished cartridge you purchase at a gun store or order online. If you reload or purchase loose 5.56mm steel core projectiles or projectile cores as components, Ruling 2026-1 is directly relevant to your situation. The steel core projectile components used to assemble SS109 and M855 are now formally exempt from the armor-piercing definition under federal law. The legal gray zone around those components is closed. The state law caveat applies to both categories. Ruling 2026-1 is a federal determination under federal law. State laws on armor-piercing ammunition are separate and vary significantly. California, New Jersey, and Illinois each have their own armor-piercing definitions and restrictions that may be broader than the federal standard. A federal sporting purposes exemption does not override a state-level prohibition. If you are in one of those states, check your state's specific statutory definition independently, because the federal ruling does not resolve state law compliance. Let me close with why the durability of this ruling matters more than the ruling's immediate practical effect. The 2015 withdrawal preserved the M855 exemption through political pressure. Political pressure can shift with administrations. A formal agency ruling under Section 921(a)(17)(c) cannot be reversed the same way. Reversing a binding agency ruling requires a formal rulemaking process, a proposed rule published in the Federal Register, a public comment period, APA compliance, and a final rule. A future administration that wanted to strip the projectile core exemption would have to go through that entire process, create a full administrative record supporting the reversal, and survive APA judicial review of its reasoning. That procedural protection is what the 2015 withdrawal did not provide, and what Ruling 2026-1 does. The green tip question, the most politically contested ammunition classification question in the history of the Gun Control Act, now has a formal, durable, legally binding answer. The projectiles are exempt, the supply chain is protected, and the 40-year fight over whether the most popular AR-15 ammunition in the country is armor-piercing under federal law is, for the first time, formally closed.